Thank you, Carlos Kiba and the band there for that amazing music, getting our Monday started on the right note. It is Monday the 28th of August 2017. Good morning and welcome to the newspaper review on the Power Breakfast Show. My name is Waihiga Mwaura. Now, it is the 10th day of the 14 days by which the Supreme Court constitutionally has to hear and determine a presidential petition, this one in particular filed by NASA leader Raila Odinga. And of course, a lot has been happening over the last couple of days. You know that on Saturday from 7, or should I say more of 7:30 p.m. in the evening, the pre-trial conference, also some are calling it the status conference, took place. And thereafter yesterday from about 7:30 p.m. as well, pretty much the same time. A lot happening in the evenings here in regards to that particular process. Rulings were made by the 7-judge bench on various issues that were raised during the pre-trial conference. Today is a very big day, bearing in mind the hearings start officially from 9 a.m. And of course, taking a look at the newspapers, that is one of the biggest topics dominating lots and lots of the pages there. And before I take a look at the papers, let me introduce my guest in studio who will help us to take a look at various issues there. I am joined by Kai Kissinger, an advocate of the High Court. Welcome to the broadcast.
Thank you very much.
In addition, we have Eric Wanjohi, a political analyst. Welcome to the broadcast as well.
Thank you.
Thank you, gentlemen. We'll have some other analysts who will be joining us in the course of this broadcast, but let's get straight into your papers. Page 1 of the Daily Nation reads as follows: Supreme battle as Uhuru and Raila papers allowed. And the little insert there says, in the clearest indication yet that this will be a bruising bar-all contest, judges threw away applications by NASA and Jubilee to block each other's evidence as Gidu allowed as a friend of court. Let me see here what the headline is on page 2, the big story there. No sideshows as judges set tempo for elections case. The first paragraph reads as follows: the Supreme Court last evening admitted all evidence in the presidential petition, setting the stage for a titanic battle between lawyers for President Uhuru Kenyatta and opposition leader Raila Odinga. Perhaps stung by criticism on the manner in which the 2013 presidential petition was handled, the Supreme Court judges dismissed all applications by Mr. Odinga and President Kenyatta to dismiss sections of evidence which was alleged to have been filed outside the constitutional deadlines. Let me begin by engaging Kai on what's been happening over the weekend. And I'd like to find out from you, how much do you think the events of 2013 impacted that decision by the 7-judge bench? How much are they relying or looking at what happened in 2013 as they, look at the proceedings on a day-to-day basis?
Thank you very much. When you remember the 2013 decision, one of the biggest challenge was the removal or non-admission of some documents that were filed by the then CORD. And CORD had filed the pleadings out of time, because by that time what we call in law pleadings had closed.
Okay.
So once pleadings close, you are not entitled to file extra pleadings, but you can only be allowed if you are given permission of the court. In most cases, courts allow if you argue it out and say, I filed out of time because of some challenges.
Also, in the past, if you have a good reason why a court can allow you to, can allow to admit evidence.
Can allow to admit evidence if you give proper reasoning as to why.
Okay.
But the courts have been very, especially now, that's unique in other courts, but in the Supreme Court has been very critical on that issue. The reason being, in 2013, the time frames in terms of determining this dispute, you only have 14 days to determine the dispute, and by the time the status conference is finished, you are left with about 6 days.
Okay.
So then the court was constrained with time in 2013 and said, look, we can't admit 800 pages. In any event, the pleadings has already closed. So we are now doing the hearing. So they expunged all that. Now, many years later, there was a lot of criticism that was received from scholars and from the public as well, that maybe they should have admitted the evidence of CORD at that time. So when you see now the impact of what they have done right now, they have run away from issues of technicality. Now remember the Constitution
on both sides.
Remember the Constitution dealt away with issues of technicality and said that in the interest of justice, you avoid as much as you can knocking out evidence based on technicalities.
Okay.
And what are technicalities? Technicalities are just like, for example, filing out of time, not signing pleadings, things like that. So now, I think based on that, the court is trying to recorrect the errors or the perception,
the perceived errors of
2013. And what you have now seen is that though all the parties wanted pleadings to be struck out for both sides, some documents, the court said, no, we are very cautious in the interest of justice. We will not deal with a lot of technicalities. That's the spirit of the Constitution, and therefore we will allow all the pleadings that have been filed, whether filed out of time, whether filed within, whether they were not served, we will allow all these pleadings. So it's an adoption and a correct change from what happened in 2013.
Okay. Let me bring Eric in on this. Eric, I know you've been following these proceedings keenly over the weekend. Your highlights so far of this particular process, day 10, less than 4 days remaining until September 1st, when the Supreme Court is expected to give its verdict there. But what's been your highlight so far?
Wahiga, this court process is very important for the country. We can see the country is really on a slow go in terms of what is happening in the political scene, and I'm very happy with the Supreme Court that has decided to get rid of the noise in and out of court.
Okay.
Because that way we are able to focus on the issues that are at hand, and they'll be able to deliver within the time frame that they've been given.
Okay.
So that is good for the country, and that is good for what is going on in the Supreme Court.
Okay.
So that has been my highlight, and I'm very proud of that.
Okay.
Yeah.
Good. Let's continue taking a look at what else the paper has in regards to this whole process. Of course, headlines on both sides, both in terms of the Nation and the Standard. Let's take a look at Standard page 1. The title reads as follows: Judges defer ruling on Raila vote audit. Okay, and the little insert there says, head to head, Supreme Court gives compromise rulings on applications by various parties to be enjoined to presidential poll petition, but defers ruling on Raila's bid to access to all Forms 34A and IBC computer servers to 9 a.m. today, which is in the next 2 hours and 20 minutes or so. Of course, that's a ruling Kenyans will be keenly waiting for. Page 6, let me just read 1 or 2 paragraphs there. The Supreme Court deferred a ruling on whether it will allow the National Super Alliance to audit electoral materials to this morning, as it allowed various parties to join the presidential election petition. According to Chief Justice David Maraga, the application by NASA leaders Raila Odinga and Kalonzo Musyoka had many issues the judges need to consider, and which they did not finish in time to deliver a ruling. Of course, being made clear here, but let me bring you in, Kai, on this. Lots of issues in which they need to consider. Were you expecting this? Was it surprising?
Yes, I think most legal people expected this.
Okay.
And I'll give you reasons why. That was the elephant in the room, because it's a very big application that they were faced during the pre-trial conference. To an extent where some parties were saying, especially the parties representing the respondents, the petitioners, that if this is not allowed, then our case basically is compromised, because it's a huge thing. Now, remember that judges, and when you look at the history of how they gave the decisions yesterday of all the applications, you remember that they took an approach, and that approach was more of unanimous. So there was unanimity in terms of agreeing on the issues before the court. So it's a good start from the court in the sense that they are agreeing on basics.
Okay.
Now, my guess will be that they had not finished looking into the issue at hand, because it involves a lot of thinking and refreshing and probably doing some research on their own. Because remember that judges don't write this without conferencing. They conference and agree on what are the general principles that will apply here, what are we looking at, what is the evidence and all that. So it's not a shock that they did not finish it. But I think what it is going to be will be something well reasoned and well researched, so that when they come to give the verdict on what they think, because they know the stakes are high, it's the elephant in the room, it has a basis on the entire case, so it will be a very well reasoned and researched opinion. However, it's not a long time, because it was only yesterday they finished at about 10, so probably they went to work. In fact, I think they must have worked overnight to prepare
this. They finished at a few minutes to 9.
Exactly. Yes. So then I'm sure they went to conference again last evening to work on it, or maybe they are conferencing this morning, but they must be having a rough draft which is developing. Okay. Yeah. Which
we will of course expect to hear in 2 hours or 15 minutes or so. Exactly. On a lighter note, many were asking whether in the future it might be compulsory for all lawyers to get a diploma in ICT. Is that a discussion that you've been having with your colleagues?
No, I think it's good to have
in mind. Of course, technology is increasingly, becoming pertinent to a lot of our processes.
Exactly. It's good to have extra papers, but then in terms of such kind of evidence that is required, you need a professional person to give evidence, and therefore there's nothing that stops the court from seeking for a professional opinion. Who really knows what it is that they're talking about, and that doesn't exclude it from the decision of the court.
Okay. Yes. Okay. Another headline, and I'll bring you, Eric, in on this just a bit. Nation, page 3. Let's go back. This is also on a lighter note. Exit Mutunga, enter the wig and the robe in Conservative court. Let me read one or two paragraphs there. Besides the urgent matter of adjudicating the high-octane presidential petition, one of the more noticeable features of the courts under Chief Justice David Maraga is the return of the robes and wigs once yanked out of the judiciary by his predecessor, Dr. Willie Mutunga. When the court convened to formally begin hearing submissions in the petition last Saturday, members of the bar and the bench showed up in their ceremonial garb, which must have made Dr. Mutunga cringe wherever he was following the proceedings from. I don't know if cringe, Eric, was the right word. Of course, you've been watching this. Your take?
I don't know whether cringe is a word to use, but probably Kaikai can tell us more on this, whether it was something, it's an official policy that has now been reversed, that they're now required to robe up.
I'll give you, thank you for that, I'll give you a small history of why you see judges wearing like this. And this happens in common law countries that practice on common law.
I'm sure we'll also be showing those pictures on the screen as the judges walk in.
Exactly, and these were common law jurisdictions, and lawyers and judges and the legal profession is very, very reserved, and they believe in customs and cultures that have developed over the years.
Common law is borrowed from which culture?
From UK.
From the United Kingdom.
From the United Kingdom.
It's important to clarify.
Yeah, from the United Kingdom. So one of our issues is that we adopted this from the United Kingdom, and it became a norm and a practice and a procedure for Kenyan lawyers and judges to rob, what we call robbing. Robbing is just basically dressing in an attire that is officially recognized. So that's why you see lawyers dressing in wigs, black gowns, and the white wig when you are appealing for a court. And judges in Kenya, we adopted the black and white. It's been a tradition for many years. Now, there's a significance in the colors. White is pure, red is danger, and black is being silent. So the court is silent in black, the court is pure in white, and the court is going to give a final verdict which represents the red you see there. So that's the jurisdiction in terms of how those colors developed. So it's a finality, a pure, and issue of silence that occurs there. So that's what common law jurisdictions practice. Now in Kenya, that has been a procedure for as long as the legal profession has existed. But then there were divisions. Some lawyers felt much later that wearing the wigs is too much. You sweat depending where you are. It's uncomfortable. It's a foreign verdict on locals. But when you look at all African countries and within the region, they still keep that practice. Now, when it came to the former CJ, we felt that he needs to change, and so I think they must have had discussions, because this is what we call a dress code. So they must have conference within the Supreme Court at that time to decide why they ought to change from the wigs. And I think during his tenure for the 5 years he was there, you wouldn't see any judge wearing anything. Neither will you see even lawyers robbing. People are just going to court in their plain suits, so long as they're black or dark colors and they're looking smart. He was comfortable with that. I don't remember seeing any judge robbing during Justice Mutunga's tenure. But that's an issue of practice that is dictated by the head of the institution. But when Justice Maraga came in, there were clear signs. Even when he was being sworn in at State House, when he was being sworn in, he was clearly in robbing himself. And remember that Justice Maraga has been in the institution for ages. He's been quite a long time in the institution. So he went back to the tradition, and there's nothing wrong with that. That's his preference. He's the head of the institution, and he went back.
What do the styles of robbing or the procedure say about maybe the leadership styles of Mutunga vis-a-vis Maraga?
One is conservative, so it means that Justice Maraga is conservative and believes in established traditions and cultures and norms of how a court is supposed to behave. And the other one probably was a freelance. And freedom in terms of you don't have to rob yourself to progressive. Actually, that's the right word. It was more progressive. But there's nothing wrong. It's a preference of a leader. There's totally nothing wrong. I wouldn't be surprised that 5 years, just as Maraga retires in the next 5 years, I wouldn't be surprised that another CJ comes in and changes. And remember the color, different style. But remember the color has changed as well. During Mutunga's time, Justice Mutunga's time, it was green in color with the yellow strips. But now we are going back to the traditional cultural way of judges dressing.
Okay, and who, again, in terms of determinant of the dressing, the Chief Justice has the final say.
Yes.
Even in terms of, I know this might sound like a small matter, but even in terms of color,
yes,
they sat down and discussed. Is there another body within
no. It's purely the dress code is purely a judicial function.
A judicial function.
And an administrative function.
Okay.
And this administrative in the sense that there's someone who will have to procure the clothing.
That's right.
That's how the chief registrar will do it. But then it becomes a judicial function in the sense that it is discussed by the judges, and they agree in terms of the color and even the design.
Okay.
Yeah. But then interestingly, you can see they're not wearing the wigs.
Yes.
Yeah, they're not wearing the wigs. So it's something that they must have also said, we don't want to wear the wigs.
Okay.
I used to wear them when I'm appearing before court, and it's quite it's cumbersome.
In fact, I was going to ask, with the complaints by Senior Counsel Ahmed Nasir about the crowded courtroom, I can only imagine how today really would have been, because I think if you calculate the proceedings today are expected to go anywhere between 12 to 14 hours. So
it's cumbersome, and when you are in a hot environment, it's more difficult to manage, like Mombasa, and I mean, you saw the lawyers sweating a lot. They're sweating. They're not sweating because but it's because of the heat.
It's not just the issues that are causing them to sweat, but
the heat,
the environment.
Yeah, the heat. Yeah.
Okay, interesting to note. Let's carry on looking at how the papers dissected the issue of the Supreme Court. We're back at, we're back in terms of looking at the Standard, page 6. Parties to frame own core issues. I'll read a bit into this, possibly 2 or 3 paragraphs, just to remind our viewers of where we are in terms of this. The Supreme Court judges failed to agree on core issues to be determined in the Raila Odinga petition against President Uhuru Kenyatta's re-election. As a result, the judges threw back the burden to lawyers representing Raila and his running mate Kalonzo Musyoka, President Kenyatta, and the IEBC to frame their own issues that they determine. Now, let me summarize some of these issues. For Raila and Kalonzo, we're talking about 28 issues as well. For President Uhuru Kenyatta, we're talking about 5 issues, and for IEBC and IEBC Chairperson Wafula Chebukati, 3 issues. So among the 28 issues, the National Super Alliance legal team wants the court to determine, in a bid to prove the election was a fraud, the issue of technology in identifying voters and transmitting results, and authenticity of forms submitted by the IEBC. President Uhuru's legal team have framed 5 issues they want the Supreme Court to determine. The main issue is whether the election for president held on August 8th was conducted in accordance with the Constitution and the Election Act, and whether President Kenyatta was validly elected and declared as president. While for the IEBC, about 3 issues, they want the court to uphold that the elections were free, fair, credible, and that Mr. Kenyatta was validly elected. Parties to frame their own issues. Again, because you're helping us to understand this, is this normal?
You know, when it comes to presidential petitions and the Supreme Court, the first point of call is the registrar of the Supreme Court, and the registrar of the Supreme Court is supposed to assist or sit down with the lawyers from different parties, the respondents, the petitioners, and others who are there to frame the issues. Now, this was attempted
on Saturday. From about 3:30 p.m.
Exactly. It was attempted, and as expected, which we all expected, they couldn't agree on the issues. Because what's an issue? An issue is a question of law. A question of law that our party wants to rely on so that the court can be able to answer it either in the affirmative or otherwise. And in terms of doing that, you will need grounds, you will need evidence-based, and so an issue is very critical in determining your case. So they couldn't agree, and what the registrar did was to refer the matter back to court during pre-trial conference. And I do recall that they said, okay, fine, we have our own issues, but we have not been able to agree. We want the court to frame the issues for us. But I think the court is being very careful here. Being very careful, because you can find yourself as a court being accused of framing issues which are not okay. So you rather take it back to the parties to frame their issues and deliberate these issues. So I think it's a cautionary approach.
That's how you do it.
That's how I will look at it. So it's now really back to the parties again, and during the trial, which is beginning tomorrow. Is it tomorrow? Today. After the trial is beginning today, there has to be clarity.
In 2 hours, and I'm actually counting down. 2 hours, 7 minutes.
Exactly, it has to be clarity. Now, what it means, therefore, that they must have very clear. I think the issue here is when you look at the respondent, they have limited issues. When you look at IEBC, they have limited issues. But when you look at the petitioner, has more issues. Because everything, I think, belongs to those issues. But then, what at the end of the day, they have been restricted, because you have to tie these questions of law into the time allocated to them. The petition has been given 5 hours only
Yes.
to prosecute their case, to show why they are in that court and to show the burden of proof. And remember, the burden of proof now entirely lies on the petition as it is. So within the 5 hours, it's up to them to decide which are the key issues we want to bring out, because time is not yes. So it's up to them to decide. They might want to pigeonhole these issues and agree among the lawyers who does which issue and all that, but then you only have 5 hours to do that. So pick the key issues, run with them, prove through evidence and affidavits and the law, and leave it to the court to decide.
Let's and we actually need to take a quick break here, but before we do that, let's try and visualize something. In the future, if we decide that this process is too short, 14 days is too short a period, and we double the period, maybe take it to about 28 days or so, how different do you think the process would be then? Everything that has been happening, how do you think things would change if the Supreme Court 7-judge bench knew that they had more time?
Now, you need to understand the history behind the 14 days. The 14 days is a calling for the Kenyans themselves. And when you look at most jurisdictions, they don't give more than 14 days.
Okay.
Apart from 2 countries that I know of, Nigeria and in Uganda. Uganda has 30 days. Nigeria gives 108 days. Now
108 days.
Yes, but remember in Nigeria,
okay, go ahead.
in Nigeria, once you are a president, there's a petition, a president is sworn in. So he takes office despite the fact that a petition is going on. So you have to determine this petition within the 108 days, but the president is sitting present. The same thing happens in Zambia, where you swear in a president within 24 hours, irrespective of the petition. Within 24 hours, swear in the president, but then the petition will go on, and within 14 days, Zambia has 14 days. Within 14 days, you have to determine the petition.
Okay.
So then it becomes difficult if, for example, the sitting president loses the petition to remove him from power. Uganda is generally
setting up structures.
Exactly. Uganda has 30 days in which to determine the presidential petition, and the president is still serving. There are only limited functions that he cannot do. Now, what could change is that, one, this is a Kenyan model which has been adopted in other countries like Zimbabwe, and therefore we are stuck with it because it's a constitutional requirement to have the 14 days, which was debated in the constitution. You remember that before there were 7 days in the Guy-led commission. Then later on in the Bomas draft we moved to 14 days. So it's been a debate going around there. But the whole idea was to ensure that you determine a presidential petition as fast as possible, because a country needs to move on. And you don't want to be caught up by a constitutional crisis or vacuum. That's what you avoid. And remember, the president under the constitution is limited in terms of functions. There are things he can do right now, and there are things he cannot by law do. So it's a bit limiting. But now to answer your question,
that's why it's necessary to have such a short period.
Exactly.
Go ahead.
Now to answer your question, in future, if Kenyans decide that they want more than 14 days, then there has to be a requirement to change the constitution.
That's right.
Now that is through a referendum. We'll have to look at the Referendum Act and change the 14 days requirement. But if you change the 14 days requirement, which can be good anyway, where people will advocate for it, then you are looking at now balancing the act between quality and quantity. Because right now, if you look at the 2013 petition, very many lawyers or jurists or scholars say that the Supreme Court decision in 2013 was not of high quality, while the Supreme Court itself is designed to make very high jurisprudential decisions
that can be used by other countries.
Exactly, by other models. So, and one of the reasons could be that time that, look, we have time constraints. Even this year, we have time constraints.
Yes.
So maybe when that is extended, we will see a difference in terms of number of hours allocated to parties, issues to be decided, more research will be put in by lawyers to look at into these issues.
More applications.
Judges will have more time to do what? To make decisions, and those decisions will be more sound.
Thank you. We'll take a short break on that note. When we return, we'll be also joined in this newspaper review by Kibe Mungai, an advocate, and Joy Mdivo, an advocate as well. You're watching the newspaper review on the Power Breakfast Show on Citizen TV. And of course, we value your feedback. Talk to us. Our SMS line 22422. Or also on social media at Citizen TV Kenya. Do you have any questions about the Supreme Court presidential petition? We'll try and go through some of them. And also the plastic paper bag ban. That's another topic we'll be handling a bit later on. If you have any questions about that as well, talk to us. We'll have some experts here in the course of this broadcast. We'll be right back.